Welcome everyone, and thanks for being on time here. We're looking to get this started in about 5 minutes. Thanks again to everyone being on time. We're just going to get this started in about 3 minutes or so. Hopefully everyone's having a good Tuesday. We'll do an introduction of Bryan Saxton here, our presenter, in about 2 minutes. All right. It's 12 o'clock. Hopefully anyone else looking to join is about to be logged in. Going to go ahead and get started here, everyone. Be respectful of everyone's time. So hello and welcome. Thank you for signing up to learn about estate planning, what it is and why it matters. We're really excited about today's presentation and believe everyone will learn something new. I'm Jason Topper. I'm here with Bryan Saxton. I'll introduce Bryan in just a minute. I'm with Turning Point Financial Services firm. Myself and my partner, Kurt LaLomia, help our clients to get their financial house in order, which often includes encouraging them to get their estate planning in order. A little housekeeping before we get started. I like to be upfront and tell everyone what is going to happen here so there's no surprises. There are 3 basic parts to this presentation. First, we will take you through everything you need to know about protecting your family with proper estate planning. Second, we'll show how this might personally affect you. There's many factors that must be considered. We'll have a Q&A throughout the presentation. Please use your chat box at any time to ask a question. And throughout, I'll try to moderate those questions and get them to Bryan along the way. Third, your participation today does entitle you to 2 free 30-minute consultations if you'd like. One on your estate plan and another on your personal finances. The 2 go together and we will work as a team to make the process as smooth and efficient as possible. Creating an estate plan requires the attorney to know all your assets, and meeting with the financial advisor first can help make for an efficient process with that. Everyone should be muted, and while your videos are on, yours do not need to be. Two things that will not happen today. One, we're not here to sell you anything. And two, we cannot provide personal financial or legal advice in a group setting like this. To get personal advice, that must be a one-on-one meeting, because we need to have all the facts about your unique situation before we can begin to offer sound advice. I'd like you all to meet our guest speaker, Bryan Saxton, who will lead us through estate planning. Bryan has his own law firm and previously worked for large firms in downtown Baltimore. Bryan's knowledge and experience in estate planning creates value and peace of mind for clients he serves. Bryan, thank you for sharing your wisdom with us today. Please take it away.
Thanks. I'm very happy to be here and talk with you all today a little bit. I am going to go through a few things as we're talking about your estate plan, as Jason mentioned. And the first thing I want to get out of the way is terminology. And you all have, if you've read the news or if you have gone through a process before, you've probably heard all these different terms and probably many, many more that may affect your individual estate plan. So, but what I want you to do is kind of not worry about these terms right now, mainly because we'll talk about the things that do matter, but there's a lot of terms that attorneys use that are legally accurate, but may not necessarily mean a lot to you. So if you have questions about specific things as we're going through, of course, as Jason said, let us know, but we're going to address the things when it matters. So one of the things that we talked about today is estate planning and why you're all here. So what is an estate? If we're breaking that down on a most basic level, your estate is everything that you own at the time of your death. So we've got a lot of different things we've included here, but that's the basics. It could be things like bank accounts, stocks and bonds, vehicles, brokerage accounts, any real estate, anything in your name. But it's really all the different categories of stuff, things that you own that goes into what's ultimately going to be a benefit for your heirs, your successors after you're gone. So if there's something that is titled in your name, that's something that's going to be in your estate. So there also are some other things, like we mentioned the individual assets, but the jointly held assets and assets that have an associated beneficiary designation, depending on things like order of when somebody were to pass, things may end up in your estate that you might not know about. Say you're a beneficiary on a bank account, or you get life insurance proceeds or retirement accounts. While those things may not necessarily pass through your estate, they could become part of your estate if somebody else has titled that and you've gotten a bequest or you've done something else. So keeping on that simple plan, like what's an estate? What's an estate plan? Again, it's what happens to everything that you own if something were to happen to you. So I've been talking about, obviously, if you pass away, if you die, but there could be an illness, accident, or even some type of travel that you're unable to make a decision for yourself about what's going to happen with your estate. So all those things that you own, if you're unable to make that decision, they may not necessarily be the things you're getting distributed to your children or grandchildren or sisters, brothers, parents, whatever it is, but also the control of how those things go. If you, like I said, if you're in a car accident or you are traveling abroad and something needs to happen, the estate plan will encompass those things. And I'll talk about the individual aspects in just a moment. So from a basic level, again, what can estate plan include? It could be your will, also known as your last will and testament, could involve trusts, which we'll hit on a little bit more in a few minutes. Most of the time, it's going to include a financial power of attorney. Sometimes you'll hear it called a durable power of attorney. Means basically the same thing with some nuance. And then also could be a medical power of attorney, advanced directive, living will. That's kind of all the same thing. And at least here in Maryland, things are usually in the same document. So I, of course, as I just mentioned, Maryland, I'm located in Maryland. I'm admitted to the bar in Maryland in the District of Columbia. So a lot of the things that I'm going to talk about are generalized, but there may be nuances from state to state if you are in a different location. So if you're in Virginia or Pennsylvania or California, wherever you are, while a lot of the things will be fairly similar, there are things that are going to be different. And so if you're in a state other than Maryland, there may be things that you have to address differently if you were to go and look with an estate plan with an attorney in those other states. But of course, if you have questions and it's a general question going throughout, I'm happy to answer them. And again, if it's a state specific question outside of Maryland, DC, I may have to defer on those questions. But the basics in almost any state are the things that we have listed here with your wills, trusts, again, sometimes financial power of attorney and medical power of attorney. So I'm going to say this, and I've started talking about things, but I'm not here to scare you or anyone else. But this stuff may be kind of scary. I talk to a lot of clients about estate planning, and every client has a different reaction because this is a big decision in a lot of people's cases, and it's something that needs to be addressed by everybody. So it can have some aspects that are kind of scary. To think about your death can be scary. But my goal here is to try to help you understand this a little bit better, understand that some of these decisions can be made without a lot of anguish. There may be anguish, and I'm not trying to minimize that at all. But again, everyone is different. When I have done estate plans for people in the past, in the last month, I have executed an estate plan with a client that from the time they engaged me to the time we executed was less than a week. I executed documents with a client this past Saturday that from the time they engaged me to the time we executed last Saturday was 14 months. So everybody's different. Everybody approaches this differently, has different things that need to play into it, but it is about your individual plan, not necessarily me as an attorney, but I'm here to help you both in giving you the information in this presentation and answering any questions you have after the fact if you'd like to set up a session to talk to me. So there are lots of different ways that you can address your estate plan. Of course, I'm an estate planning lawyer. I deal with estates both on the front and the back end once someone has passed away and needs to dispose of assets. But there also are things out there that I'd be remiss if I didn't mention. You all have probably heard about LegalZoom and Legal Shield and those type of things, and they do have estate planning services. I don't want to say that you shouldn't use those because if their decision is, I can't pay an estate lawyer and I need to have something in place, I would rather you have something in place than not. So if that's your decision, I need to use LegalZoom or an attorney and I can't afford an attorney, you can use LegalZoom. But I will tell you that in my experience, those websites and documents that you get from those services are almost every single time not as comprehensive and not as specifically tailored to the individual situation that you may have. And they often, again, not always, but often will not account for changes in the law that may have happened, and sometimes long-standing law. They specifically just don't have it in there. But again, if it's between using as the state attorney or using that website and you can only afford the website, I completely understand. One thing on here is having a non-estate lawyer friend prepare a will for you. That is something, with all respect to my non-estate lawyer friends, I would absolutely not do that, because a non-estate lawyer is going to have a specialty in some area, whether there's criminal law or family law or personal injury. And those are areas that I wouldn't want to touch at all. Like, that's not what I do, so I wouldn't want to touch it. If I tried to dabble in that, I would be committing malpractice. And I'm not going to say somebody would be committing malpractice to draft a will for you, but they're not going to understand the nuances of estate planning, trust, that type of thing, even if they're saying, oh, I'll just do a simple will for you. So while you have that lawyer friend, and if you have a car accident, they're going to be able to help you with personal injury, or if you have a problem with the law, they can help you with a criminal charge. I would certainly recommend trying to find an estate lawyer to help you out. And again, this isn't a sales pitch. I'm not saying you have to use me for your estate planning. I'm just saying find an estate lawyer if that's your decision. You want to work with a lawyer. Make sure it's a lawyer that does this as opposed to somebody that's just dabbling in it. And DIY, I mean, this is kind of an outreach of the websites. I have been involved with litigation for DIY wills in the past. And some of you may have heard the term what's called a holographic will, where someone writes out a will in their own hand and it's considered to be valid in certain circumstances. That's true, but you can get in a lot of trouble doing a DIY will, either pulling a form randomly you find on the internet, going through one of these websites is the kind of advanced version of the DIY. So I would just caution you, be careful if you're looking at DIY estate plans, and doing it yourself may get it done, but it may also not get you to where you need to be. So
Hey,
now
Bryan,
getting into
Bryan, real quick question.
Yeah, absolutely.
Someone did ask, what if they have multiple assets in multiple states, right?
So you want to do your estate plan primarily in the state where you are residing. So if your primary residence is in Maryland, for example, and you may have a house in the Outer Banks and you may have condo in Florida, whatever it is, if your primary residence is in Maryland, that's where you should be doing your estate plan, because the way that the estate is going to be probated, meaning how it's going to be dealt with by the courts and by your executor's personal representatives, is going to be based on where you're living at the time that you pass away. Like living, not necessarily that you're on a trip and you pass away on a trip, but where your residence is when you pass away. So if it's Maryland, that's where you should do it. If you've retired to Florida, but still keep a house in Maryland, Florida is the place that you should do your estate plan. So the will cover those things. You may have different trusts that would cover properties in different states. But then once the estate is dealt with after you pass away, they will have the primary estate where your residence was, and then what are called ancillary estates. So it's just for a specific piece of property in those other locations.
Great, thank you.
Any other questions before we move on?
Not at this time.
Okay. So wills will be the first thing that I touch, and this is kind of a cornerstone for every single estate plan. This is the document that I customize most when I'm doing things for people. But I want to get into what happens if you were to pass away without a will. And that's called dying intestate, meaning you don't have a document that's governing where things go. And so the things that I've included here are pulled out of the Maryland statutes about what happens to your assets if you die without a will. Some of these things may work for you. Some of them won't. If you don't have a will and you would want everything to go to your spouse, even if you have children, the statutes are not going to do what you want them to do. If you want them to be divided between your spouse and your children automatically, that's fine. But it's not always the situation. It's, for example, you have a spouse, no parents, no descendants just being your children here, your spouse gets his estate. That might work. But let's say you don't have a spouse, don't have any children, and you're estranged from your parents. Well, the parents would get the entire net estate. And even if you have siblings or friends or charities that you would want your assets to go to, you don't really get a choice if you have the will. So the will is really you being able to have that choice and put that choice into place now, so that when something happens to you, you can make sure your assets go where you want them to be. That's not to say you can't change it later, and people do change their wills occasionally, not every year. Some people change every year, but it's really taking it out of the hands of the Maryland General Assembly or the legislature in whatever state you're living in to ensure that the assets go where you want them to go. So with your will, what does it control? And we talked about what your estate is, but not all of those things that I included in your estate are included under your will. So your will does do what's called probate assets. And probate, to go into that term, all that means are these are things that when your will is submitted in Maryland to the orphans court, that these are the things that your will is going to control. So probate assets equates to property a will controls here, and they're controlled by the court. So that's your individual assets, all those things we talked about. So anything that you have that's vehicles, brokerage accounts, the things we talked about. The one thing I'll point out here that I didn't hit on a lot is assets held jointly with another without a right of survivorship. Like if you own a piece of property with a sibling, you own a property with your sister, for example, and you're each 50-50 owners. Your 50% ownership would be governed by the probate estate, by your will, unless there's some other agreement to the contrary that you have with that sibling. So that's what would go in the things that we cover when we draft a will. So the things that aren't covered are the other categories that we talked about with your estate. That's those jointly held assets, things that are held with the right of survivorship, meaning if something happens to me, this account automatically goes to my spouse. That's anything that I have I have three brothers, for example. If I owned a piece of property with all three of them and it's by right of survivorship, if something happens to me, the three of them automatically share in my interest. So that's what we're talking about with the jointly held assets, things that are titled jointly but have that right of survivorship. That is not covered by your will. That's something separate that you can talk about with an estate plan and what it would govern. Those can be dealt with without a will. And also the same thing with things like retirement accounts, things that Jason and Kurt are dealing with, retirement accounts, life insurance policies, talking about pay on death and transfer on death, bank and brokerage accounts. Anything that has that type of beneficiary designation that says this is what happens when I die, that doesn't become part of your estate. The one exception I'll give you is if you have something like this, have a retirement account or a life insurance policy, for example, and you don't have a beneficiary that's living at the time that you die, that then becomes part of your estate. And I will say that you don't want that to happen. And so I've certainly helped people, but Jason and Kurt, they're helping folks make sure that their beneficiary designations are right. And if you have, whether you're working with them or a different financial professional, they're going to be able to help you out with making sure that happens. So those things are not covered by a will itself. So depending on your situation, will outside of your assets is going to cover different things. We're going to talk about who your spouse is if you're married. If you're divorced, we want to make sure that they're not named in your will. Any children that are yours by birth or adoption, or that may be born after the date of the will. If something happens to you and your spouse, for example, and you have children under the age of 18, who are their guardians going to be? Who's going to be the person responsible for taking care of them when you're not there, whether it's relatives or friends or somebody else? Who is going to be the person that's in charge of making sure that your wishes are met when your estate, if something were to happen to you? So that's when I use the terms personal representative or executor, you may refer in some state. All that person is the person who's going to say, here's what their stuff is, here's everything they have, here's what the will says, and here's where it's supposed to go. Specific requests can often be in a will, because sometimes we'll say things like all my assets to my spouse. That's very straightforward, but there may be something specific. Like in my situation, I have a very antique pocket watch that my great-grandfather had for many years, and I was asked to make sure that it always goes to my oldest living male relative. So in this case, or child. So in this case, it's going to go to my son. And that's specifically named the will. And my will says if he's not around, then it goes to the oldest child of my sibling. So it could be something like that that says, here's what we want to talk about. Sometimes you don't have to do those things in the will, but that the will is where you would cover those things generally. But again, not always. Funeral instructions you may include in your will. But there's a reason I have maybe here, because most of the time, I would say people are not going to be looking for your will if you were to pass away. If it's something that's a long illness, or somebody is 98 years old, maybe they know where the will is. They've already looked at it. They know what the instructions are in the will. But if, say, something were to happen and it's unexpected, it's unlikely someone's going to go searching for your will before they make funeral arrangements or for burial or cremation or whatever it may be. So those are things that certainly would while we could put them in the will, and we sometimes do in specific circumstances, most of the time you want to make sure you've talked to your loved ones and to ensure that that's dealt with. And then wills also deal with things like taxes and expenses, which I'm not going to get into. Estate taxes and gift taxes, that's beyond the scope of this, and we could talk for hours about that. But if you have questions about a specific situation, of course, we can get into that at a later date.
Before we get into this
Yep.
diagram, just a couple things popped up. One of the questions was, do you need to file a will with the court? And the question with that, it goes, what's the best way to store and make sure that will is going to be found and available? I know there's situations where, a relative maybe has a will, but they don't know where it is or they can't find it. What are your suggestions around that?
Sure. So in Maryland, you can submit your will to the Register of Wills, and depending on the county, it's either $5 or $10 for putting your will on record. It's not public records. They put it in a file. They have an index of it that they have it there, and it's there in that county where you live, and it's able to be found. So some people like to do that. I have clients that certainly do that, but not always. I personally have my will in a fireproof safe that's sitting here in my office where I am. So if something were to happen, that's where all my important documents are. And if there were a fire, for example, it's going to be at least hopefully fairly protected there. But it's really becomes personal choice. Sometimes you may want to have, sometimes lawyers' offices, and I don't, and because of a long story, which I won't tell you about a past firm, but some lawyers' offices have their own fireproof safes that they include all their clients' files in if you would want to keep them there. And so that's obviously a possibility, but it's really a question of keeping something safe and letting people know about where it is. So if you've named somebody to be your personal representative, your executor of dealing with your estate when you're no longer here, it's always a good idea to just tell that person, here's where I'm keeping things. So my wife is my first one, but after her, my brother is my backup, and he knows that my documents are in the fireproof safe in my office, and if he needs to get it to anything, and he knows where the key is, and I trust him to be able to know that. So that's certainly what I would say you can do. One thing I would tell you to never do is put a will in a safe deposit box. The reason being is that if you put a will there and something happens to you, and the person who's your personal representative is not an owner of that safe deposit box, they're not going to be able to get to that will to even know that they're your personal representative. So you're kind of in a catch-22. The document says they have the right to marshal your assets and take control of your estate, but they can't get into the box because there's no document saying that they have the right to do that. So it's certainly something I encourage my clients to avoid and do that. Now, if you don't know where the will is and you know there is one, certainly search for it. But I would recommend in that case where it's like, we did a will 15 years ago. I have no idea where it is. It's probably a good idea to think about doing a new will to make sure that you know where it is and can be able to tell the personal representative, here's where it is.
I'll add one quick thing to that. I mean, I know with us and our clients, we have a cloud vault storage location that, we do hold important documents for our clients, and they can access it, and their, POAs can access remotely wherever they live in the country, which is a nice option as well. And, it's pretty secure, right? I guess anything's potentially vulnerable online, but that's an option. And then one more question before you move on, it might tie into where you're headed. The question was, with a will saying, I guess the estate's going to pass to the siblings and their descendants, if one of those siblings doesn't have any children, but they have stepchildren, does it automatically go to them? I don't know. You want to touch on that?
Yep. So I'll touch on that question in just a minute as I'm getting to the next slide. But one thing I want to say about the secure vault, which is absolutely great, and I love that idea for being able to access the documents. And one of the reasons I didn't mention electronic documents for your will is that when you submit the will after someone passes away, you have to submit an original. So there are times where if there is you don't have an original, you know, electronic copy, we can have a conformed copy probated with a court and have a hearing about it and have different affidavits. But so certainly keeping your documents in a secure electronic vault is great, but that original will is also very important. So make sure you're keeping that physical copy somewhere and you don't destroy that and just rely on your electronic copy. You want to have that original will.
Thanks for the clarity.
Absolutely. I appreciate you mentioning the electronic vault. So anticipating the question that Jason asked about what happens in situations where you have siblings that may or may not have children versus other people that do have children. This is kind of an example. And I basically, this says what happens if Alan were to predecease Bonnie, what happens to assets upon Bonnie's death and things getting distributed. On the basic level, per Stirpes, and you may have heard this, it's the general way that attorneys write and other folks write distribution of assets, meaning by the branch. So if you have 4 children, for example, the assets go and are divided by the branch. So in this case, Charles, David, Ed, and Frank, and I'm not going to go exactly with this situation, of course. If David and Frank survive, they get their share when something happens to Bonnie. Charles and Ed didn't survive. Charles' share gets divided by Greg and Henry. Ed's share would get divided by Jenny and Isabel, but of course, Isabel's not in the picture. Jenny would get it, and then Lance, Manny, and Nancy. So it's just basically saying each branch gets the share, and then that branch, if that person that's the head of the branch isn't there, everything that's further branches gets that share. But the question that Jason mentioned that someone asked is, what happens if there is a stepchild there? The question I would ask back usually is that stepchild adopted by the sibling? Because that makes a difference in the way things are handled. Because the way I write and most state attorneys write our wills is that if we're doing something per Stirpes by the branch, like even children who are subsequently born or adopted after the date of the will are covered. It gets murky if you have stepchildren that aren't adopted by the sibling. So there are various ways to handle it. The way that I typically advise that we handle it is that if you want those stepchildren to get something in the event that, let's say that in this case, Charles has Greg and Henry are stepchildren and they aren't adopted, is that we say specifically in the document, if Charles is not alive, Charles' share goes to his stepchildren, Greg and Henry. So you address that specifically in the drafting, and that's something that the attorney drafting things really needs to know about is an adoption situation, a non-adoption situation, so you can customize that, because the default would be if they're not adopted, they're not children under a document and they wouldn't be covered. So all of these situations, again, it's why working with an estate attorney, again, whether it's me or somebody else, having that customization is really going to help you out and make sure that your situation is specifically covered. So I mentioned probate a little bit, and I'm not going to talk too much about this, but it basically, probate is the process that is required to patch the probate property, so property covered by your will, to ultimate beneficiaries. So the steps in Maryland, it's fairly straightforward. I will not say that it is straightforward in every single state, because other states, it is a more complex process. And sometimes people talk about avoiding probate, for example. And depending on the state, that may be a good idea. And some people will do a lot of trust to avoid probate. In Maryland, it's not necessarily required to avoid probate because the probate process here is more straightforward and doesn't have as high fees as other states' probate processes. So the probate process is basically that you open an estate, have the will, if there is one. If there's not one, it makes it complicated, have the person representative, and then administer the estate. So the process itself is really just to get your assets together and make sure that the assets are distributed in the way they're supposed to be, including filing tax returns and things like that, paying off any people that are owed any money, any creditors. So avoiding probate is a question I get very often. And, while I said in some states it is better to do that depending on your level of assets, the downfall you're going to have is if you want to avoid probate completely, you don't want to have to open up an estate with the courts, is if you have to retitle every single asset that's in your individual name. So if there's a bank account out there that you forgot about that has $10 in it, technically you got to open a small estate in Maryland to deal with it, even if every other asset is titled properly. So for most people, trying to keep track of that every time they buy a car, sell a car, buy a house, sell a house, all that thing, it's not worth it. And you end up spending more money to retitle assets than you would going through the probate process. So in some states, it's worth it. In Maryland, my professional opinion is that it's not worth it to do that. Now, there may be situations that you want to do something to avoid probate for certain types of assets, whether it's for estate tax purposes, gift tax purposes, but not generally the entire estate, and avoiding probate in total. In Maryland, it's just not necessary to do that. Again, if you want to, we can make it work, but it's probably going to cost you more than you'd be saving on the back end. So one of the ways that people will do that is through trusts. And I want to mention trusts here. And I've used a few examples of trusts here. And the only one I'm going to really talk about in any depth is a revocable trust. That is usually the vehicle that people get in states that don't have a fairly reasonable probate process will use. They put every asset they own in a revocable trust, which means it's revocable. You can take anything out of it, put anything into it, just get rid of the trust at any point before you pass away. So that's usually the planning vehicle that attorneys will use in other states to avoid probate, is having this revocable trust. And the trust is written kind of like a will is, that says, here's what happens to all my assets when I die, and so that you can avoid the trust situation. But there are so many different types of trust, more than I could list here. But these are kind of the most often ones that I see. And I don't even do all of these. Some of them are very specialized, like an NFA gun trust. So if you have firearms that are federally regulated, for example, there are people that specialize in that. I don't do those. They're way too specialized. I don't have malpractice premiums that are high enough to deal with those. So there's all different types of trusts that may be applicable to you, whether it is, like I said, the revocable trust, irrevocable trust. If you have minor children, we always recommend a contingent trust for minors that may be built into a will. And so if there are specific questions about trust, I'm happy to address those offline, but I would be remiss not to mention them as part of this. So Jason, I think it'd be a good time to answer any questions about an estate right now, if those are any of the questions that are out there, before I move into powers of attorney and advanced directives.
Yeah, no additional questions yet at this time. Have one coming up a little bit later on living will. But
okay, perfect.
Yep.
All right, so we'll move into a power of attorney, which is, to me, with a will or a trust, it's an integral part of your estate plan. Definitely a power of attorney is as well. And most of the time we deal with what's called durable powers of attorney. And durable simply means that if you become incapacitated, again, not die, if you die, the power of attorney goes away. It's only for when you're living. But you are in a car accident or you're in a coma and you're unable to make decisions. Durable simply means that the rights granted under the power of attorney survive that incapacity, then allow somebody to act when you're unable to do so. So what a power of attorney does, it deals with your financial matters to allow another individual to be able to act on your behalf. Generally, they are very broad financial powers. Sometimes they can be narrowly tailored in certain situations, like somebody's selling a house and they need to be able to allow somebody to be a power of attorney on that behalf. It could be in other limited situations, but often as part of an estate plan, it's fairly broad that, for example, you want your spouse to be able to sign things on your behalf without you having to worry about it. And I'll give you a perfect example, which was a few years ago in my own situation. I was traveling a lot for work. My wife and I were selling a previous home, and we needed to sign a sale contract because we got an offer on our house. Instead of me having to find a business center at a hotel, my wife was able to sign as power of attorney on my behalf. We were able to accept the contract and we're able to move on without having to deal with a lot of hassle. So that's a very simple situation. I was able to sign on my own behalf, but my wife was able to do that. Another example would be someone who, like I said, is in a coma or is in an assisted living facility and may have dementia, that signed a financial power of attorney before they were unable to make decisions on their own behalf, and allow their siblings or children or whoever it may be to be able to pay bills and deal with bank accounts and mortgages and things like that on their behalf. So if you don't have a financial power of attorney, you have to go to a court and get a guardian appointed or a conservator. And I'll throw out the pop culture reference. Britney Spears' dad is her conservator. Sometimes you don't want to deal with that level of oversight, but a financial power of attorney will allow someone to be able to make those decisions on your behalf. Allows that individual, rather than a court, to be able to determine what happens with your financial affairs while you're still living. Again, power of attorney is only while you're living, and a will is what happens. So that there's that dividing line: power of attorney while you're living, will after the date of death.
Brian, I got a question for you on that.
Absolutely.
So that is great. You can feel good that you have this durable power of attorney, but I mean, being in the financial services industry, some firms might not just automatically accept your durable power of attorney. They might be resistant to it. I've seen where they have their own paperwork that they want you to complete directly with them. Have you seen that? Or do you have any comments on that?
Yes, Jason, I've absolutely seen that. And it really does depend. Sometimes the financial institutions want that, and I understand the reasons why. I will blame it on the lawyers and their lawyers saying, we want this specific form that we like. But one thing to keep in mind is in Maryland, and other states have similar things, we have a Power of Attorney Act that promulgated a power of attorney that's in the Maryland Code, that if you use that form power of attorney, financial institutions that do business in the state are required to accept that financial power of attorney or face fines. And so when I'm doing financial planning, and again, everyone, an attorney that's a good estate planning attorney, which is most of us that are going to do this in Maryland, are going to use a statutory form. We may have another form that we use as well and have you sign both of them, but using that statutory form power of attorney gives you that benefit of the financial institutions getting in trouble with the Attorney General's office if they're not accepting it. So if you're using some other form that you just found online that's not the statutory form, the institutions are within their rights to reject that, but they can't if it's the statutory form.
Great. Yeah. I think that's just something that's good detail to understand with certain financial institutions, and you think you have the right paperwork, and it may or may not be unless like you said, it matches the Maryland code. So thanks.
Absolutely. And I'm sure many other attorneys write what we call nasty attorney letters to banks all the time saying, this is a statutory power of attorney. If you don't accept it, we're going to go get all these damages, and usually that wins over their legal departments. So that's the benefit of having an attorney draft it for you, is they can say with confidence, this is the statutory form, and we're going to go after whoever if they don't accept it like they're supposed to. So advanced medical directives is the next part of the plan. And again, this document, where we have the will that governs after you pass, we have the financial power of attorney that governs while you're living for financial matters. A trust may straddle the line if you have a trust in your estate plan. An advanced medical directive, living will, is also one of those documents that kind of straddles the line. So you may have heard the terms living will, medical power of attorney. In Maryland, we put them all in a similar document, and they're all there so you can sign one time and be able to use this for medical care, or if something were to happen to you, for things like organ donation. So on a basic level, the document is telling medical professionals what you want to have happen in certain situations if you are unable to make decisions for yourself. It usually will designate an agent and often an alternate agent to make those decisions when you're incapacitated and unable to do that. What those decisions are, whether the agent is supposed to do exactly what's in the document or has some flexibility, and then also deals with consent to things like organ donation and other things that would happen with your body after you pass away. So there are a lot of different situations that are covered in this, which I can certainly go into if people have questions. But these really came into vogue, for lack of a better term, for those of you that remember the Terry Schiavo situation several years ago, where her parents and her husband were fighting over what would happen in her case because she couldn't make medical decisions on her own behalf. And after that situation, I won't say it didn't happen before it certainly did for a lot of attorneys, but after that, every attorney in our estate planning process is going to recommend, you don't have to, but recommend that you have advanced medical directives, living wills, medical power of attorney, whatever it's called in the individual states, want you to have that, because we don't want there to be a situation where people are fighting for years and years and years, and you very clearly knew what you wanted to have happen in these certain situations. So while I mentioned that some of this stuff is scary, and it is, to think about what would happen if I'm in a persistent vegetative state, and what do I want to have life-sustaining procedures, or do I want to have someone take me off life support, whatever it is. So it's a difficult document for folks to get through. And so I would say that in addition to the will, I often spend more time talking about what's going to happen with an advanced medical directive than we talk about what's happening in a will for clients, because they know, like, something happens to me, I want everything to go to my spouse, right? But if there are these certain situations for medical procedures, here's what happens. And so I have clients that are physicians. I have clients that work in other areas in the medical field and have talked with them about these documents, have drafted these for them. And we've had very in-depth and serious conversations. So this is often somewhere where we have a lot of those conversations. But generally, these come out when you are incapable of making a decision for yourself. And it's not going to be like you pass out because you had blood taken and somebody that's sitting there going, okay, whatever we're going to do to put them under right now. No, that's not what this is intended for. This is intended for when you truly are unable to make a decision, you're unable to understand the nature, extent, consequences of your medical decisions, evaluate risks and benefits. You can't communicate any understanding in any way. Again, it's not that you can't talk, it's you can't communicate understanding. If you can look at someone and write down and blink twice to say, yes, I understand, the medical power of attorney, advanced medical directive doesn't apply. You're able to make your own decisions. But if you are unable to understand, you're unable to make those decisions, that's when this would come into play, and your agent would be able to address those situations. So Jason, I know you said you had some questions about living will. I don't know if I've addressed them already or if you want to ask them.
Yeah, I think you did. It was just, the question was, what's the difference between a will and a living will, right? So the will, like you said, is after you've passed, it directs, your assets and things. And the living will is obviously while you're still alive, the medical, instructions, how you want to be cared for when you can't speak on your own behalf, I believe, right?
Absolutely.
Yep. I don't know there's any other questions right now, but again, if you do have a question, anyone, there's the Q&A section. You can just type your question in there and we'll try to get you an answer.
So I've mentioned this a few times, and talking to attorneys, I mean, estate planning attorneys specifically, is I truly believe that I'm here to help people. And I think that other estate planning attorneys are as well. We certainly are doing this for our job, but we want to make sure that you understand the decisions you're making and are here to help guide you. We can't make decisions for you, obviously, that we can suggest options for you. So again, that's why I recommend talking to an attorney who's knowledgeable about this, because we've been through this process ourselves. I've done the will and we've made mistakes in our own process. I give you an example. I had to get a surgery a few years ago because I did something stupid and hurt myself. And it's like, you know what, I'm an estate attorney. I should look at my will before I go under anesthesia just to be safe. And my son, who was 5 at the time, I hadn't updated my will to even include my 5-year-old son in the will. Now, the language would have included him because, as I mentioned earlier, children born after the date of the will would have been covered, but his name wasn't in there. And I can't imagine a 5-year-old would have been too upset about not having his name in the will. But, at this point, now that he's 10, he probably would if he wasn't named in Dad's will. So we understand things slip through the cracks. We're here to help. And again, I've had clients, we can get this done quickly because they want to get it done quickly. And some clients, the decisions take a while. So I tell all my clients, I'm here to guide you, and attorneys in general are here to guide you and not force any decision on you, but help you decide what's going to be best for you and your individual situation. So that's what I had in terms of the content I went over. I know if there's any other questions, I'm happy to address them.
I got two questions that came in. I'm going to expand on this one. Dawn had asked, if you move states, should you do a new living will? And I would expand, how about your basic will and, everything if you're now in a different home state?
So the famous lawyer answer to almost any question is it depends. And so I will give that in this situation, but it depends on which document. And I'll take them in turn. So if you have executed a document in general that is valid in one state, it's going to be valid in other states under the full faith and credit clause of the Constitution. In general, there's always exceptions to that, but that's the general principle. So for wills, that's usually the case. So if you are moving to another state and you are moved from Maryland to Florida, for example, and you passed away 2 weeks after you got there, unfortunately, your Maryland will still be honored and it will still be effective for you. What I recommend, though, if you are moving states, for things like the living will or advanced medical directive and the financial power of attorney, because of things like the Maryland Statutory Power of Attorney Act and other states having similar acts, you want to think about getting those type of documents updated when you move to another state. Because let's say if you move to, and I don't know if Florida has a Statutory Power of Attorney Act, but if they do, you want to make sure your power of attorney is on their form. And while you could still submit your Maryland power of attorney down there, having that updated is beneficial. Same thing with the living will. Most of them are fairly similar from state to state, but different states may have nuances that you want to address. And doing that when you move is a good idea. A will, going back to that, it may be a good idea for you to update it, but you may not need to. I mean, of the 3 documents, that's the one that I have most confidence in saying, if you're updating these documents, that's kind of third on your list when you move to another state. If you're going to be living there long term, you probably want to think about it at some point. But let's say you just executed your will a year ago and then you move. I certainly understand not incurring the cost to update that right away. But again, with full faith and credit, it should be honored.
Okay, great. 2 more questions. One was for the advanced directives, broad or specific in your what you request for yourself?
In terms of what the decisions are in the document?
I believe, yeah, regarding to your medical care. I mean, I would think maybe specific, right? That way there's less room for judgment.
Correct.
Okay.
Yeah, so there are a lot of different options and a lot of different situations that are covered, and they are more specific in the document more often than less. And again, thinking of the Maryland Advanced Directive Living Will, for example, it deals with after I pass away, I consent to organ donation. And it has specifically, these are the situations that I will enable my organs to be used for transplantation, for therapy. It could be for medical study programs. So all those specific items are things that you can choose from and say, yes, this in this situation, it applies to me. Same thing if you're in a persistent vegetative state, there's different options of, do everything you can to keep me alive versus the more lenient options of, keep me comfortable and let me pass if I'm not going to survive, whether you get pain medication or not. So there's a lot of different decisions that go in there, and it is specific. The one thing I mentioned earlier that I want to reiterate is when you're naming your agent, one of the options is I want my agent to follow everything in this to the letter of what's here. And they have no flexibility. Versus I want them to use this as a guide, but they have flexibility in interpreting these. If there's a situation that's maybe a little bit gray, but fits mainly in one of these categories, I give them that power to make that decision. So while there is that specificity, there is an opportunity to say, I can't foresee every single situation, and I'm allowing my agent to make decisions that are in my best interest.
Great. And I've heard things like, to be specific for what you like, right? If you hate having socks because your feet are always warm and you don't want socks on, like people put, no socks on my feet. Or, if I like a certain type of music played, right? If you can't speak for yourself at that late stage in life, you could put things like that in. And, if it's possible, I think, maybe people would try to do, those specific things if they can.
If people want to do that specific, we can absolutely make it happen.
And then there was a question about trust for minor children, since they shouldn't be named in a will for minors. I don't know if we got about 5 minutes left or so.
Yeah. So usually when you're dealing with a minor child, and in Maryland, it's a little bit interesting the way you deal with minor children, because a transfer to somebody under the age of 21 in Maryland is subject to the Maryland version of the Uniform Transfer to Minors Act, meaning that there needs to be a custodian appointed over those assets for the best interest of the minor. And like Jason said, in a will, you don't want to just say, I give everything to my 5-year-old. It just doesn't work, and it's not reasonable, and it's just going to cause all kinds of headaches. So what we'll typically draft is what's called a contingent trust for minors, as we indicated earlier, and Jason just mentioned as well. And what that trust does is, the reason it's contingent is if you're survived by your spouse, usually everything goes to the spouse most of the time. And the trust wouldn't come into play unless something happened to both parents. But the trust puts everything in trust, including other non-probate assets, if you title them correctly, like life insurance accounts and that type of thing, so that there is a trustee appointed who oversees assets for the child's best interest, can expend money for things like education and living expenses and food and healthcare and whatever else they need to for the child's best interest. But the child can't get access to those trust funds until they reach a certain age. Some people will say that age is 21. I've had clients that say, when my daughter's 18, I don't care what the Uniform Transfer to Minors Act says. I want them to be able to have access when they're 18 because they're that responsible. Some people are the other way. If you were not responsible when you were in college, like I was, unfortunately, with money, you say, maybe there's a trustee can expend money for their behalf, but you have an older age, like 25 or 30, before someone can get access to the principal of the trust. So again, the trustee is expending money for the benefit of the child that's the beneficiary of the trust, but they may not necessarily be able to get access to the proceeds of a $2 million insurance policy. So that's a pretty common vehicle that I use and others use for making sure that assets for the benefit of children are taken care of.
Okay, great. So let's move to the next slide, and we'll just recap here everything. So again, wanted to thank everyone for attending today. Feel free to email us here. We have Bryan's information and myself and Kurt LaLomia's information. If we didn't get to your question, or if you want to, more of a confidential one-on-one, please just reach out to us directly. As we mentioned in the beginning, your participation today entitles you to a complimentary consultation with Bryan or, me or Kurt. Bryan's going to be a help on the estate planning piece. And if you would like to have more of a, direct one-on-one, personal financial conversation, me and Kurt can help you out with that. We work as a team. Financial planning, estate planning really complement one another. Similar information is needed by, both parties. So, we can help make those customized recommendations for your specific situations. So just email or give us a call and we'll see what we can do to help you out. And hope everyone enjoyed Bryan's presentation today. Bryan, I think it was great. You covered a lot of things. And, again, give us a call or shoot us an email if we didn't get a chance to answer your questions today. And thanks so much for everyone for attending. Thanks again,
Just one
Bryan.
quick thing before people
Sure.
jump off is that, folks, I've already had one message asking for the PowerPoint presentation. I'm happy to share it. If you wouldn't mind just sending me an email and asking me for it, I will send you the presentation in PDF so that you can open it pretty easily.
Yeah, absolutely. I did put that in the chat in the beginning. Happy to send this out to you. Just send Bryan a direct email and he can get you the presentation. Thanks again.
Thank you, everyone.
Thanks so much, everyone. Have a great day.